I call the member for Wright.
Thank you, Madam Deputy Speaker. And I actually rise to speak on Fairwork Registrations Organisation Amendment Bill 2012. This bill will amend the Fairwork Australia Registration Organisation Act 2009 to increase the financial accountability obligations of registered organisations and their office holders, strengthen the investigation powers of Fair Work Australia and enhance remedies under the Registered Organisations Act. Let me start by highlighting the need for greater oversight of registered organisation has come from Fair Work Australia itself. In its recent statement regarding investigations into the HSU, Fair Work Australia said of the Health Services Union, "The investigation reveals an organisation that objectively failed to have adequate governance arrangements in place to protect union members' funds against misuse. Substantial funds were, in my view, spent inappropriately, including on escort services, spousal travel and excessive travel and hospitality expenditure. These revelations are clear indicators that there is an urgent need to ensure that monies paid by members to a registered organisation is used for proper purposes." The 1,200-page report that detailed the financial misuse of in an inappropriate manner in which the hard-earned money of Health Services Union members was spent by senior union officials to the disgust of the people of Australia. It is an absolute shame that an organisation that has purported for many years to represent the hard-working Australians and their rights has now been exposed to having zero regard for respect of those workers. In saying that, I do associate my comments with previous members who have highlighted that there are unions that do an outstanding job, both in the workplace. There are organisations that do represent their members and provide value. And I was always of the opinion that unions could have done much more, in particular in building the Bowen Basin and now the Galilee Basin. Unions could have done a lot more in providing far better value for their employees, but that's a debate for another day. The revelations that union members' money was spent on union officials, on escort agencies, travels, restaurant and huge cash withdrawals are a disgrace, to say the least. It clearly demonstrates that there is an urgent need to ensure that monies paid by members to registered organisations is always responsibly appropriated in a transparent way. Today's bill will amend the Fair Work Registration Organisation Act 2009, which sets out the statutory obligations and privileges for so-called registered organisations. These include both federally registrable employer associations, trade unions and federally registrable employer associations, which include employer associations and industry associations. The task of administering obligations and responsibilities imposed on registered organisations currently belongs to the General Manager of Fair Work Australia. Such obligations include ensuring that financial statements and associated reporting requirements are met. Powers include the ability to conduct inquiries and investigate into registered organisations and pursue allegations of breaches. This bill seems little more than a hasty attempt by those opposite to give the appearance that they are making an effort to resolve many issues plaguing the oversight of registered organisations. The reality is this bill falls well short of doing what is necessary when we in the Coalition have a number of real concerns with it. The rules and requirements as a result of the changes are still significantly weaker than those expected of company directors. And I bring the House's attention to company directors. When you hear that term, one automatically thinks of the corporate top end of town, the monopoly type of corporate director. Well, that's not necessarily the case. My corporate directors, my company directors in my electorate, they're the local mechanic. They're the local butcher. They may be someone whose combined household income is around $100,000 per annum, and the advice that they have received from the taxation office, rather than give $50,000 to the husband and $50,000 to the wife, which is often the case, for taxation benefits, the advice they receive may be to set up a company structure. So I employ the House, when you hear the term company director, don't think of the Reserve Bank, don't think of those board directors on multinational companies. Send your mind to the local mechanic and the local butcher and the local businessman, because they are the people in my electorate which will be ultimately affected. The rules and the requirements as a result of the changes are still significantly weaker than those expected of a company director. While penalties are in line with other civil penalties in the Fair Work Act, they still fall considerably short from those required under the Corporations Act. So here we have a situation where we've got one set of rules under the Corporations Act for our company directors and another set of rules for our union mates. It's a juxtaposed position. And why are we here at this position having this discussion? Why is this bill before the House? Because it was only last week when in the Federation Chamber I'd put up a private member's motion which seek to implement a plan that will expect the same standards of accountability and transparency of union leaders that are expected of company directors under the Corporations Act. And you should have seen the Labor members of this House with union links that got up and said, we don't need any more transparency. We oppose the private member's motion that you put up because we don't believe that actually there was a member who supported my motion because he was actually there and listened to it. The others that came in were automatically opposed. The reason I put the private member's motion up is because the unions were calling for it. The unions themselves, through the papers, through their organisations, were calling for it because there is a stench around the union movement at the moment with reference to transparency and accountability. Take, for example, the comments from Australia's Council of Trade Union Secretary David Oliver. He said that every union member has the right to know that their money is going to be subject to good governance and regulations. Australian Workers' National Secretary Paul Howes then said he supports bringing unions accountability and transparency in line with the Corporations Act. So here we have two predominant unions saying that they support stronger transparency in the organisations. Furthermore, in his opening address for the 2012 Congress, Mr Oliver said that unions have significant responsibility to members to ensure and make double sure that members' money is only used for the purpose to advance members' interests. Findings during the recent Fair Work Australia report would leave those comments in question. The bill, while expanding police cooperation powers, doesn't make it expressly clear that Fair Work Australia can cooperate with police. Given the track record of Fair Work Australia, is it important that this is made absolutely clear? And I'd ask the Minister, when giving his final comments, to clarify that point. In addition to clarifying their responsibility with police, I also would like to have some further conversation put towards the brief of evidence from Fair Work Australia for its transition through to the next progressive path in the event of untoward activities. Furthermore, there is express provision to allow Fair Work Australia to provide a brief of evidence to the Directors of Public Prosecution. Given previous problems with this, it is important to give the express powers to allow for this to happen. It should be noted these provisions are frankly unnecessary, but need to be supported given the circumstances. As my colleague who sits here in the chamber, the member for Wright, recently pointed out the question, why has this bill come about? In a previous speech, she made that point. Why has this bill come about? Why all of a sudden now does the political wing of the union movement feel though a stronger stance against corruption and misappropriation must be taken? Is it because the right and the honest thing to do? Is it a proactive step to stamp out cynicism within the union movement? Is it to finally put on a level of legislative playing field that its corporate equivalents are on? To impose the same kind of punishments or infringements where the only difference is where the money is coming from? No, it's not. The government's lack of moral fortitude to do something like that is simply because they were shamed and embarrassed into some reaction through the scandals and the disgrace that the Health Services Union plagued this government. It is because they have been shamed by the strong leadership demonstrated by Tony Abbott on the issue and the strong stance that he is taking in bringing this situation to the fore. The Coalition is proposing 8 amendments to improve the design of the bill and to improve outcomes for workers. Most importantly, we create a new organisation to oversee the registered organisations. Now, in setting up this organisations in the amendment, we would suggest that this will be supported by the government because it is absolutely in line with the government's and is consistent with the government's position on the Safe Roads legislation, where they appropriated $15 million to set up a tribunal which would oversee road fatalities, so-called road fatalities, and to oversee workers' contracts in the transport workers sector. So what we're asking for in an amendment has a precedent, and we would suggest that this government will and should support the amendments attached here. The Coalition will seek to remove the responsibility of the General Manager of Fairwork Australia to ensure compliance and a shift to a new, separate and independent body which will be called the Registered Organisations Commission. This commission will fall under the auspices of the Office of Fair Work Australia Ombudsman. It will be able to use the Fair Work Ombudsman's network and resources where appropriate and will ultimately report and be answerable to the Parliament. The Coalition's amendments includes provision that, should a report be delayed, the Commission must report to the Parliament and inform the Parliament of why there is a delay. Madam Deputy Speaker, it is just unfathomable that the time that Fair Work Australia took to process recent investigations is nothing more than shambolic. More than shambolic. We must implement changes in legislation that can expedite or to shift away from a place where situations like that can never be repeated again in this country. The Commission will also be responsible for educating registered organisations about the new obligations and will be able to receive complaints from members and provide information about what they can do if there's a problem or a complaint, just as there's a specific rule which applies to companies and board directors to ensure that they are doing the right thing. The same rules should apply to registered organisations and their officers. As such, the Coalition will move amendments to ensure that the penalties are the same as those expected of company directors and ensure that the Registered Organisations Commission will have powers broadly in line with those provided to the Australian Securities Investment Commission. When we come into this House, we get often bashed up about saying no, no, no. The reality is 80% of the legislation that goes through this place is unopposed. I just got corrected by the member. 87% of this legislation that goes through here is unopposed. We do support good legislation, but we will be the first to oppose bad legislation. One key amendment will seek to bring across Section 184 of the Corporations Act into the Registered Organisation Act. This would make it a criminal offence if bosses of registered organisations do not act in good faith, if they use their position dishonestly or if they are reckless. To wit, the Coalition's amendment will seek to further increase penalties in line with the Corporations Act. Believe it or not, the penalties are comparable offences by the officials in registered organisations are almost non-existent. Similar obligations under Section 287 and 288 of the Fair Work Registered Organisation Act 2009 using information for personal advantage or determining of an organisation are limited to civil penalties of $2,200 for an individual, and there are no criminal provisions. In conclusion, I believe that this is a poor bill that will not deal with the substantive issues born out of Fair Work Australia's investigations. It goes without saying that the seemingly ever-ending saga of Fair Work Australia's investigation into the Health Services Union has made it absolutely clear that major reform in this area is needed. However, I believe that the reform is needed to manage rather than the legislation. The assessment of the former Attorney-General, the Honourable Robert McClellan, MP, in a submission by the Institute of Public Relations stating the areas of the bill that can be strengthened is highly accurate. And his comments were, the bill is a step in the right direction, however its reforms are modest and do not go far enough. Madam Deputy Speaker, and finally it is without doubt that this bill and the proposed coalition amendments are a sure method that will provide greater protection to the Australians to Australians in the workplace. For too long, unions have escaped proper scrutiny and finally has exploited the investigations of the Health Services Union and the proactive investigations by Fairwork Australia. I commend this bill and I commend the amendments.
The member's time has expired.